Our next panel, to many of us, don't need much of an introduction. I think I have the privilege here of introducing three distinguished and accomplished individuals that are also professors here at the University of District of Columbia. The Honorable Peter Panuthos has served as special trial judge on the United States Tax Court since 1983 and has served as chief special trial judge since 1992. In addition to his service on the bench, Judge Panuthos currently teaches tax procedure and substantive tax courses here at UDC-David School of Law and Georgetown University. Judge Panuthos recently received the J. Edgar Murdoch Award in 2012 for distinguished service to the United States Tax Court. To his right is Professor Charles Jeane. Professor Charles Jeane is the director of the Low-Income Taxpayer Clinic here at UDC-David School of Law. Prior to joining the School of Law Clinic, Professor Jeane clerked actually at the United States Tax Court for the Honorable John F. Dean and Judge Panuthos. Professor Charles Jeane is also an alum here at UDC. And lastly, but certainly not least, Professor Dan Clark is a professor here in the Housing and Consumer Law Clinic at the UDC-David Clark School of Law, where he supervises student attorneys representing tenants and consumers in various civil and administrative matters before the DC courts and administrative agencies. Previously, Dan was a managing attorney with the DC Bar Pro Bono program. The panel here today is going to discuss access to counsel, specifically with Judge Panuthos and Professor Jeane, with regards to the tax court and tax procedures. And Professor Clark is going to touch on the implications with regards to pro se representation and brief services and how that might not necessarily be an obstacle to access to counsel.
Okay, I think I'll just...
Okay, I'm going to put the microphone just right here if you need it.
Okay, thank you, and good morning. It's incredibly nice to be here and see so many of my former students who surprise me all the time by saying how relevant Tax 1 federal income tax was and is in their lives and their law school career and beyond. And particularly nice to know that even some of you graduates, including Professor Jeane, who's sitting next to me, and also Amanda Dunlap, who's a former graduate, is sitting in my chambers right now as my current law clerk. So I really honor all of you, and I appreciate you being here today. So what I want to do is take a few minutes and talk about the Turner case, but I also want to talk about the tax court and how this interaction is really important, and then pass it on to the other panelists. I've been a judge at the U.S. Tax Court for almost 30 years, and we currently have about 28,000 cases pending. Of those, 19,000 of our petitioners are unrepresented or self-represented. So that's about 68%. And it's really important to recognize and remember that even though the taxpayer is a petitioner in our court, that they are responding to government action. And if they don't respond to government action, whether it be an adjustment to their tax return or to a response to a notice of levy, possibly taking away their money out of their bank account or driving away their automobile, or in fact foreclosing on their home, that if they don't take that action, that in fact they end up possibly homeless, destitute, and end up becoming a member of the society that needs government assistance. So the idea that they may end up in a judicial proceeding, the 68% without counsel, is really unacceptable to me as a judge. And one of the things that I've done over my career is to look to other resources, recognizing the current status of the case law, that there is not an absolute right to counsel in civil cases, and that is the development of clinical programs and pro bono programs, and using other resources, given again that the resource of this right to counsel is not available. So the goal has been to at least try to make access to counsel available to every litigant in our court. Some may choose not to access that right, but providing the opportunity for counsel has been a goal of mine for better than 20 years. And let me just also mention one other thing before I talk about Turner, and that is that that a judge's role with a self-represented individual is particularly difficult. And that is that there is clearly an imbalance because, of course, the Commissioner of Internal Revenue Service, who is effectively like is a party in every proceeding in our court, is represented by counsel. There's no less than about 1,000 lawyers who work for the Internal Revenue Service around the country who show up at every calendar call and represent the Commissioner of Internal Revenue Service in every case. So when an unrepresented or a self-represented taxpayer comes forward, he or she is in, clearly an imbalanced position. So what is the judge's role in that, recognizing that imbalance? To what extent does the judge examine a witness, cross-examine the witness, ask leading questions of a witness, cite the law to the witness, or I should say to the litigant, so that the litigant can possibly comply with or indicate the level of compliance with the law. I don't necessarily have answers to all of those questions. Fortunately, some of the more recent case law has, and some of the judicial ethics provisions have assisted the court in at least describing the area of acceptable conduct of our judges. So let me just go on to another track for a moment and talk a little bit about the Turner case. I was interested, and I really appreciated the prior presentation by Mr. Pollack about Turner, and talked about the bad news of 2011. And I think I tend to be a person who looks at glass half full rather than glass half empty. And in fact, Turner did do some things that are useful and helpful, I think, to the courts. And one of the things that happened in that case is the federal government actually filed an amicus brief in that case. And the reason for the reversal, I think, was really what the U.S. government did as amicus. So, but let's just back up and talk very briefly about the facts. So, in 2003, Mr. Turner, who had failed to pay child support for a number of years, and he was, by the way, the order of child support was $51.73 per week. One might have thought that the judge at some point would have asked him whether or not he had the money to pay that, but somehow that didn't happen. So he spent some time in jail over a period of 2 or 3 years, and then he gets out in 2006. He's back out again, fails to pay child support again, and this time the judge, at a civil contempt hearing, asks him, do you have anything to say after the civil contempt proceeding has been brought? And he goes into sort of a litany of how things have been tough for him, that he's had a drug problem for a number of years, and essentially, I think his last line of the statement quoted by the Supreme Court is something like, "The dope made me do it." And the judge in the South Carolina court finds Mr. Turner to be in civil contempt and puts him in jail for a year. It goes to the South Carolina Supreme Court, which affirms. It's notable that in the state proceeding, the judge also had a form which he needed to sign, and it was just again form language which said something like defendant was not gainfully employed and had the ability to make the support payments when due. And somebody stamped that, or judge signed, put it in front of the judge and signed it. Fortunately, Mr. Turner was able to get pro bono counsel at some point, and ultimately went up into the federal court system arguing a due process argument, the due process argument being that Mr. Turner couldn't pay, and there was a due process violation by holding him in civil contempt and incarcerating him as a result of the violation of the failure to comply with the South Carolina court order. When the case got to the Supreme Court, the United States of America filed an amicus brief, and in the amicus brief, the United States argued not only, even if there's not an absolute due process right to counsel in this case, there are certainly certain things that didn't happen below that should cause the Supreme Court to overturn the decision of the lower court. And one of those things was that, again, the litigant, Mr. Turner, had never been apprised, or no one ever really asked him, by the way, do you work? By the way, can you afford to pay? Because remember that what civil contempt is about is the failure to comply with a court order. And again, South Carolina law provided that someone could be incarcerated for failure to comply with a court order under civil contempt. That's the way that family law and the way custody and child support was enforced, and it is enforced in a number of states. So the Supreme Court, Justice Breyer, in a 5-4 decision, held that clearly this is not a Sixth Amendment case, it's not a criminal case, even though there's a potential, and in fact there was incarceration. In fact, what South Carolina argued initially is the case was moot, because at this point, of course, Mr. Turner had long been out of, long spent his year in jail. Fortunately, the Supreme Court dodged the mootness case and said, well, this is going to be repetitive, it's just going to happen again and again. So they disregarded the mootness and actually went and answered the question. And so the Supreme Court set forth, and talking about prior case law, the 3 sort of tests that they believed counted. And one was the nature of the private interest affected, the comparative risk of erroneous deprivation, and then the procedural safeguards that might be put in place. And as far as the private interest, the Supreme Court made clear that incarceration and loss of liberty was certainly a loss of a private interest, and therefore, to that extent, the court could consider that Mr. Turner should have the right to counsel. But then they looked at the opposing interests, and what were the opposing interests? Well, you had who was actually bringing this action, and what the Supreme Court said, well, this was really a private action by the mother of the children, and suggested that there would be, and this was referred to earlier, an asymmetry if you gave the right to counsel to Mr. Turner, given that that the mother of the children, Mrs. Rogers, did not have counsel. I sort of scratched my head on that one, and I wonder if that was, my sense is it was probably a compromise to get this 5-4 opinion out, because in my mind, when you're in a contempt proceeding, once you're in a contempt issue and an issue of incarceration, it's really not a private party that's bringing that action. It's really the state that is really the moving party. So it's really here, Mr. Turner down here versus the judge in the South Carolina court here saying you're going to jail if you don't do certain things. But what the court did do, and sort of brought into the federal government's argument about, well, maybe there are alternatives here, and some of the alternatives might be some other safeguards. And they talked about 4 safeguards. One is the notice to the defendant of the ability to pay. Seems pretty obvious, but here clearly Mr. Turner had not been given the clear notice. 2, the use of a form to elicit financial information, so suggesting that the court do something more. And The third is the opportunity at the hearing for the defendant to respond to questions about financial status. So clearly the court should have, asked and inquired. And then, of course, an express finding by the court that the defendant had the ability to pay, to hold someone in contempt. If someone can't comply because of an ability to pay, they're not in civil contempt. They simply can't pay. That's where the Supreme Court went in 2011. It's a very recent case. I'm pleased to say that at the tax court, which, by the way, the judges travel and sit in 75 cities, we've recognized this civil right or at least that we want to provide access to counsel. And when I made a presentation at the law school some 10 plus years ago and suggested that a tax clinic was an appropriate thing for this law school to operate, and I was pleased that they did that. And so I'm going to pass this on to my co-panelists to talk about how the UDC clinic operates, and I think we'll take questions at the end. Does that sound good? Right. Okay, great. Thank you.
Good morning. I'll echo the judge's sentiments that it's nice to see some former students and add that it's nice to see some current students this morning. I am the director of the Low Income Taxpayer Clinic here at UDC, and I just want to talk a little bit about how the clinics are here to provide representation for low-income taxpayers, and then a little bit about materials that are available to all pro se litigants, mainly through the tax court's website. Clinics are provided for in the tax code. 7526 provides the establishment of low-income taxpayer clinics, and I won't go into all of the minutia of the tax code because I know that's not what you want to hear. There are 100 participating clinics. There's at least one clinic in every state and 2 actually in DC, one here and one at American University. And you can, if you're looking for a tax clinic, you can find those listed both on the tax court's website and on the IRS's website with address and phone number. And unfortunately, no matter how many times I call the IRS, they put my direct line as the phone number for the clinic. So maybe I should just stop trying to get that changed. But a lot of petitioners are notified of the clinic's existence through what we call a stuffer notice that is sent out from the tax court itself. And it's sent to every pro se litigant. And they either get a standing pretrial order if they're in a regular case, or they get a standing pretrial notice if they're in what we call an S case, a small case, which means the amount is under $50,000. And so that stuffer notice goes out and lets them know, because that they are pro se, that a clinic may be able to help you with your issues with the IRS. And so where this kind of comes into to play is there are income guidelines for low-income taxpayer clinics, and they are low, the income guidelines. And so while the clinics are here and can provide representation for low-income taxpayers, there is a large swath of taxpayers out there who don't qualify for assistance by a clinic because they just make a little too much money, but not enough money to hire a private attorney to come to tax court for them. And so the clinics are also, we go to calendar call programs. Of course, we go to the calendar call program in the city where we're located, so we actually go to the main tax court building, and we go, there's actually a calendar call next week being presided over by Judge Panuthos, and we'll go to calendar call, and an announcement will be made that a clinic or clinics are present, and if you want to speak with them, they may be able to help you. And again, we might pick up a case there, or we might just give a consultation because the taxpayer still makes too much money. We still have to check our income guidelines even through that program. And then there are also what are called calendar call programs, just so you know that they're there, which are pro bono attorneys that will come to calendar call to help with those cases. And so just to kind of shift over, so I don't take too much time, the tax court website, which I had up here and was really tiny on the screens anyway, so if it doesn't come back up, it's no big deal. I don't think you could have read it anyway. It's pretty user-friendly, and up at the top there are several tabs, and one of the tabs is just called Taxpayer Information. And you can actually, when you click on that tab, it will take you all the way through a tax court case, from before the trial to during the trial to after the trial. And it's got a lot of helpful information for a pro se taxpayer, and gives them information. A couple of them that I think are really important, or one is examples of what to write in your petition. As Judge Panuthos mentioned, in tax court, the taxpayer is the petitioner, and most of the time is the party that has the burden of proof, and so they're the one who has quote unquote brought this case because the government said, no, you owe us more money. But they have to fill out a petition, and although those petitions are read as generously as possible by the court, because if they are a pro se litigant, it still has to have an argument. It has to state a claim in it, and many taxpayers will often just write, "I don't agree with what the IRS said." Well, we figured that. And so it's really nice that the website lays out some phrases you should use. You know, I don't agree with the IRS disallowing my dependency exemptions and earned income tax credit claim because my children lived with me all year. Or that you don't agree with additional income because you never worked at the company that provided the 1099 to the IRS. And that's really helpful then for not only the court, the judges that hear it, but if a clinic gets involved later in the case, that there's actually something for us to work with. Which often happens is we don't usually get a case when they got the notice of deficiency. They've usually already filed their petition, or we meet with them at trial. There's also a great tab on the website for a trial prep checklist, which gives the petitioner what they need to bring with them to prove their case. Law clerks at the tax court don't normally go to trial sessions, but when I clerked for Judge Jeane, he had a trial session in Baltimore, so I went up there, and there was one couple that had several years at issue. They did not have counsel, and they spent the majority of their time talking about 2006, and then when they got to 2007, and they said, we can prove that we had that all of these deductions are proper. And the judge said, okay, well, let me see your receipts. We don't have them. We left them at home. Well, it's just not very helpful. You know, and if I have a feeling if they had looked at the website before they came and looked at the checklist, they might have brought all those things with them. So just to kind of finish up, Judge Panuthos gave you a little bit of statistics about how many pro se petitioners the tax court has. And just to kind of give you some numbers, this is from the Taxpayer Advocates 2012 annual report to Congress, and just kind of some overarching numbers on the most litigated issues. 13% of pro se taxpayers prevailed on some part of their case. 13% of those that came. 28% of those represented prevailed on at least some issue in their case. So it really does matter to have an attorney present, especially in the tax court for legal issues that are often very, very complicated and not exactly the same as what a layperson thinks a dependent is. The legal definition is a little different. And I would add, sometimes hard to find in the tax code that's about that thick. So that's just a little bit about how the tax clinic helps pro se petitioners in the tax court. And I'm going to turn it over to Professor Clark and we'll take questions at the end.
Great, thank you. It's an honor, Judge Panuthos, Professor Jeane, to join you this morning. Thank you to the organizers and to all of you for the opportunity to address you. It's really interesting to hear about what the tax clinic is doing for unrepresented litigants in that realm. It's a little dangerous being a proponent of brief services at a symposium around the idea of a civil right to counsel, because as John Pollack pointed out this morning, brief services, alternative legal services models to full representation are often cited as reasons why a civil right to counsel isn't necessary, that the unmet need can be filled by other types of service, like unbundling legal services, pro se coaching, court-based assistance, pro se information, and so forth. And so I feel it's a little bit dangerous to address you as a proponent of brief services in that context. But what I want to share with you is the idea that I think it's wrong to think of brief services as being in opposition to the civil right to counsel. And I think I would like to describe to you the experience of students in the housing clinic here at this law school and their experience providing brief services at the Landlord Tenant Resource Center, and share with you why I think that a well-designed and a well-integrated brief services program actually can effectively supplement the full representation model and actually supplement the argument that a civil right to counsel is necessary in certain areas, like the housing area where, as John Pollack pointed out, shelter is one of the basic human needs that's been identified as an area in the civil context where litigants would benefit from a right to counsel. So in the housing clinic here, the housing clinic at the David A. Clark School of Law has been in existence for decades and has earned a reputation, well-deserved reputation, for taking on complex housing matters, particularly in the area of rental housing. These matters sometimes go on for years, and students are able to really get into complex matters and provide full representation in those matters. I came to the clinic with the idea that we could supplement what the housing clinic is doing in these complex matters with providing an opportunity for students to provide brief services through programs like the Landlord Tenant Resource Center, which is a pro se court-based assistance center at the DC Superior Court located in the Landlord Tenant branch. And I think the Landlord Tenant branch is a really a great place to experiment with different legal services delivery models, because so much is at stake for the litigants. The Landlord Tenant branch is not properly named. It's really the eviction court in DC. The plaintiff must be asserting a superior right of possession and suing for possession of real property. So it's not a housing court where anyone can sue a landlord or tenant about all landlord-tenant related issues. It's really just an eviction court. There are over 40,000 cases filed in that court each year, and as Mr. Pollack pointed out, about 98, by some measures, about 98% of the tenants, of the defendants in the landlord-tenant branch are unrepresented, and about 86% of the plaintiffs are represented. So it's a huge imbalance in terms of which parties are represented and which are not. But that's still a pretty high percentage for the plaintiffs, 14% unrepresented. And that was something that, as the DC Bar Pro Bono program was developing the Landlord Tenant Resource Center, that had to be taken into account as well. And the experience, once the Resource Center was operating, is that there actually are quite a few plaintiffs who sort of meet the criteria of what traditional legal services providers apply to their clients in terms of income eligibility and unmet need and so forth. And just to illustrate, because the landlord-tenant branch is an eviction court, you may have a public housing tenant who has a guest who won't leave and is unable to remove that guest from their public housing unit without going to court and suing for possession. And someone like that is an excellent candidate for a free attorney. because their public housing benefit is in jeopardy if they're unable to remove the person from the unit to, without court process, they're unable to effect. So just a note there too, that it's not just the defendants in a court like the landlord-tenant branch that benefit from the brief services that are made available, or even sometimes from representation itself. And so the Landlord-Tenant Resource Center serves about 5,000 unrepresented litigants a year. It's based at the DC Superior Court, right adjacent to the courtroom where the cases in the Landlord-Tenant branch are heard. And it started in 2004. It was the result of a study of the Landlord-Tenant branch. The DC Bar Landlord-Tenant Task Force studied the operations of the Landlord-Tenant branch, made recommendations about how that court could better expand access to justice, better serve the unmet needs of the litigants in that court, and operate more effectively. And one of the primary recommendations of that report was that the bar create a pro se assistance center at the court. And in 2004, the center launched. And the history of how this played out, I think, is a really good example of how a brief services component can actually support the argument that there's a need for a civil right to counsel. The Landlord-Tenant Resource Center started operating in 2004, and the numbers of litigants who came for assistance was overwhelming. Impressive and overwhelming. And one of the things that provided an opportunity for the Resource Center to do is to gather data about the needs that were being presented by the unrepresented litigants who came for assistance. And it also allowed the Resource Center to gather anecdotal experience about the people who were coming and didn't have counsel and how they could benefit from counsel. And those arguments were very instrumental in securing public funding for what's called an Attorney of the Day project. And I think it's since 2007 the Attorney of the Day project has been operating in the Landlord-Tenant branch in conjunction with the Landlord-Tenant Resource Center. And in this way, I think what we're seeing is that the entire spectrum that Mr. Pollack alluded to this morning is being provided, and it's being provided in a way that's more effective than it would be if there were only actual representation. And it's because the Resource Center or other brief services programs like that can act as a big open door, which is traditionally a function that's met by legal services providers' intake system. But rather than an intake system that's only designed to screen cases for actual representation, the screening process is happening while services are being provided to the unrepresented litigant. There are some unrepresented litigants who present who are very sophisticated, who are not low income, who really are just seeking access to information or to forms or to tools that they can use. There are other litigants who present at a court-based assistance center like the Landlord-Tenant Resource Center who are very unsophisticated, have complex legal matters that they don't understand, and it's the Resource Center is able to identify when a litigant like that presents and then refer the matter to the Attorney of the Day project. And in that way, it's sort of a seamless delivery system that works better for all the litigants at the Landlord-Tenant branch, not just the low-income litigants there. And so having in place a pro se assistance center, court-based, like the Landlord-Tenant Resource Center, created a great opportunity for our housing students to start experimenting with providing these brief services. And so in the housing clinic, students are required to complete a quiz about substantive housing law before taking on actual representation. And so getting the students to the point where they take and pass the quiz is the sort of the threshold that we established for students participating in the Landlord-Tenant Resource Center. Certified student attorneys are acting as the attorneys at the Landlord-Tenant Resource Center, a function that's normally handled by volunteer attorneys, mostly from large law firms in the district, but other volunteer attorneys who are organized by the DC Bar Pro Bono Program, and then supervised by a DC Bar Pro Bono Program staff attorney at the court each day. So the certified student attorneys in the housing clinic were able to fill the attorney role at the Landlord Tenant Resource Center on various different occasions throughout the semester, and to have this opportunity to provide service in one morning to 3, 4, or 5 unrepresented litigants in the Landlord Tenant branch. And so it's a really concentrated opportunity to practice the skills that are such an important part of what students are learning in the housing clinic, and to apply their legal analysis in a really concentrated fashion in different matters, and to sort of go through that learning process that happens over a period of weeks, tutorials, seminar, to really concentrate that into an opportunity for students to get feedback from the supervisor immediately and to apply that knowledge, and then to even in some instances see the feedback, because it's not uncommon that the Landlord Tenant Resource Center, for a litigant who is scheduled for court that same day, to have an interview with an attorney, to get assistance from the attorney, say, for example, drafting a motion to stay execution of a writ of restitution so that an eviction doesn't happen, an imminent eviction doesn't happen. A student may have an opportunity to help draft that, to provide information and counseling about how to present that in court, and then to see the pro se litigant actually present that in the courtroom the same day to see the results. It's also an opportunity for the students to see where the unmet need lies. And finally, I would like to say that out of this experience, what I've gained is the idea that maybe law schools should consider creating a brief services clinic and integrating that into the clinical program. And the reason is because I think it provides an opportunity for the students to have these learning opportunities, and also provides an opportunity for the clinic itself to perhaps more holistically deal with its clients, and provides the students an opportunity to study the delivery of legal services in a clinical setting. My idea for a brief services clinic, just briefly, is that rather than as an intake function for all of the other clinics, that a brief services clinic might take referrals from the other clinics in a law school clinical program. And in that way, if, for example, the housing clinic is dealing with a client with a landlord-tenant matter, but that client also has other matters that the housing clinic is not equipped to address, the housing clinic could refer that client to the brief services clinic. Brief services clinic could do the intake on those other unrelated issues, provide advice about those issues, and provide referral to an appropriate provider for additional services, hopefully full representation. And so it's in that way that I think we may want to consider thinking about brief services not as an argument against a civil right to counsel, but rather as an argument for a civil right to counsel.
Thank you, Professor Barker. Jeane, do we have a couple minutes for questions? Okay.
Yeah.
So, questions? Second, third vote?
Professor Clark, I would think that brief services would definitely benefit the litigant, but I would think at some point the advantage would somewhat taper out. So, for example, you have maybe a pro bono attorney who's providing, or a law student who's providing a limited retained agreement to vacate a default judgment. But once that pro se litigant has his day in court, then they somewhat end up back in the same seat that they would have been in, because they can't articulate why they shouldn't have to pay full rent, why the protective order wasn't proper, and whatever other legal defenses they may have in the housing case.
I think that's right, and I think that's why having a robust system that provides a whole spectrum of services is so important. In the Attorney of the Day project, the example you just cited sounds very similar to what the Attorney of the Day might do. A low-income tenant is unrepresented, comes to the Resource Center, half an hour later is meeting with an attorney from the Legal Aid Society about how to get that default vacated. The Legal Aid Society attorney of the day represents the tenant in the courtroom the same day. The motion is granted, the default is vacated. Now, the administrative order that has been in place at the landlord-tenant branch allows for a temporary appearance for the attorney, and that appearance automatically withdraws that same day. But in the administrative order, there is a presumption that the attorney will continue and provide full representation. And so for the litigant who needs the full representation after that first day in court, there's a presumption that that service will be provided. Frankly, if the tenant loses the hearing, that may be the end of the road, and so it's appropriate that there's only representation for that same day.
There was another question, and then Mr. Paul.
I know that in the Social Security context, part of the reason that private attorneys kind of fill the gap is because there's a funding mechanism if they prevail in securing the Social Security benefits that are in play. Is there a similar mechanism through the tax code, through federal regulation that might provide incentive to compensate attorneys who are willing to take on tax matters to represent?
There's two funding mechanisms that come to mind, that neither of them really are based upon success. And the two funding mechanisms are that some with around $8 or $9 million, which is really a very small amount of money, is available for matching funds for clinical programs. So the some 180 programs around the country, 100 of those that work with us in the tax court do receive matching funds, as does UDC, and I think the maximum amount per year is $100,000, but generally something a little less than that. So that's one. There's another sort of backdoor, and that's that if a litigant was successful in the tax court, and the litigant also showed that the IRS action was unreasonable, not fully justified, not reasonably justified, I forget the exact legal terminology under Internal Code Section 7430.
Substantially justified.
Substantially justified, thank you, Charles, good student. And then they might be able to get attorney's costs, including if Charles' clinic were representing that litigant, he could bring money into UDC coffers for the substantially unjustified action of the IRS. Those are really the only two.
Wait, did I hear UDC coffers?
I knew I'd get your attention. Yes.
So I wanted to, first of all, just say I appreciate, Professor Clark, your more nuanced description of the relationship between right to counsel and other programs, which I pretty much agree with. And we do view it as a spectrum, and I think the only important thing is to ensure that whatever we're doing, that we're testing it to make sure it actually works, and not simply assume because it's cheaper that we don't need to, or free in some instances, that we're not under the obligation to ensure that whatever these programs are doing are meeting the needs of the client. The question I have for all of you is, do you believe that Turner v. Rogers created an affirmative obligation on the court to determine if its process is meeting due process, or do you think the litigant has to raise the absence of due process in order for the court to address that?
My personal belief is clearly that the court's got an obligation to make sure that there's due process. I mean, why am I in a courtroom? Why am I a judge if I'm not, being certain that due process and I would hope that others would look at it the same way. And again, that due process would not necessarily mean the right to counsel, although my personal belief is at least access to counsel, the opportunity for counsel, and that's why I felt so strongly about making sure that every unrepresented taxpayer that comes before me has been given a notice that there is an organization in the 75 cities that we sit in that would have an opportunity, that they would have an opportunity to talk to and meet with and actually have representation. So I do think my view is that there's an act, that it's just simply not sit back and wait for it to be raised.
Part of the reason I ask is that the Court of Appeals in Georgia just decertified a class action on the right to counsel on the basis that the litigants hadn't asked for counsel.
Yeah.
And that raises the question again of whether or not they have the right is the question that the court has to answer. If the process that was in place was not sufficient, then Turner leaves open the possibility that counsel would have been necessary. And the court said, because they didn't raise it, we're not gonna reach it, which is kind of a circular
Sure,
problem.
sure. Turner leaves open another question, as I'm sure you're aware, and that is that this asymmetry that was talked about in Turner, and the fact that it was, quote, a private litigant, that is the mother of children, that was bringing this action and resulted in civil contempt. And Turner suggested, Justice Breyer said clearly, the next time around, if it's a state that is bringing the action for the collection of monies, that we might look at this differently. And I've already expressed my view that, in my view, a civil contempt proceeding really is a state action. It's not, and the reason that there wouldn't have the asymmetry if the state were the collecting agent, because the state, of course, is represented by counsel, whereas Mrs. Rogers, in this case, who brought the initial action for support payments, was representing herself. Other questions?
Mine is a purely practical one. Let's assume I'm a pro se litigant in tax court proceedings and I missed my stuff or notice about the clinic, and I don't have access to a computer, or even if I did, really wouldn't know how to navigate the internet. But I'm savvy enough to know there's probably a form out there I need to fill out because I have to fill one out to file my taxes in the first place. What do I do? And how do I know how to do it? Like, is there a place I can go get paper forms? How do I find out where that place is? How do you reach folks that, the main question, how do you reach folks that aren't tech savvy enough to watch a website? Sure,
I believe you can get a paper petition from the tax court, if you went to the tax court and went to the records office. But I don't think that they have those petitions at all of the cities that they sit in. I'm not sure.
No, but there is if you were to call, and this is pre-computer, because we had what we call the kit, and we've had that kit for 20 plus years, and it's a big envelope with a second envelope in it, and the second envelope is addressed to the United States Tax Court, so the petitioner can't misaddress the envelope. And I think they do need to put postage on it, although I think it might be delivered even if it's not posted. But in the envelope is a form petition and some written instructions to the litigant. And now we even put in a CD, which if they do have a computer or a CD player to play it on, they could actually get this 40-minute video, which will tell them step 1, step 2, step 3. So it's not only computer-based, and this was in existence well before computers. I think Brian had a question.
I did, just kind of along the same parts of, I was kind of curious what the most common route to deficiency is for most, taxpayers that are kind of bringing themselves into the tax court, and that if the information the IRS is providing to them is sufficient, that they would not necessarily go over to look just the stuffer thing, but that they say to make it onto the website. I know a lot of times I did the housing clinic for essentially 2 semesters worth, and it took, despite there being a lot of information out there, it took an extra person to be like, these are the magic words, right? And then to be able to get to the point where Judge Panuthos is sitting on the bench, hemming and hawing whether or not he should alert the witness to the fact that you have to say this magic thing or I can't help you.
Well, I think, like I mentioned, they do give some examples of what you can say, and the petition itself does say that you need to kind of line by line say what you disagree with from your notice of deficiency that the IRS has sent you. But I also believe that because in S cases, in small tax cases, the petition is read pretty liberally, that unless a taxpayer really does just write, I don't agree, they've written something in there that is a claim and gives you at least an inkling of what it is they're saying they don't agree with, the assessment that they're not agreeing with. And then, of course, where a clinic comes in is if that person, we have a case currently right now that is a docketed case that we'll probably file an amended petition because the petitioner didn't know exactly what it was he needed to be arguing. And so outside of those kind of two avenues, either seeing what is already, what some examples are, and speaking with a clinic. The IRS doesn't give you anything, I mean, outside of just, they do lay it out, everything that they are saying is wrong with your return for that year is in a separate section. So they don't just say, you owe us $10,000 more, figure out what was wrong. They lay it out line by line, what they're saying the issues are. And then what the petitioner has to do is, the petitioner has to disagree with all of those, or the assumption is that they don't disagree with that change.
And also, no pro se petitioner is going to be kicked out of court simply because they didn't articulate well their claim. But it's nice if the issue could get focused before the morning of trial. It's helpful, but sometimes it doesn't. Thank you. I think our time is up. Thank you.